Hello everyone. Today I'll be speaking on the topic of prosecution. Now, why prosecution? Recently, the Ministry of Finance in a press release has mentioned that over 2,225 complaints have been filed by the department, which marks a stark increase by 184% when compared to the last year, because last year only 784 complaints were filed by the department. And in fact, there are a few more press releases, a few more news reports also, which mention that the prosecution notices have been issued and are being issued. And hence, in view of the above, this video is made for the purpose of for the education of all the taxpayers, the SSEs, the tax practitioners, and all the legal practitioners, so that appropriate replies can be filed in response to the prosecution notices, and so that the steps are known as to what to be done during the prosecution proceedings. Now, firstly, let's understand under the Income Tax Act what steps or what measures are provided for the purpose of tax compliance. It's a three-way mechanism has been provided. Firstly, by levy of penalties, second by levy of interest, and of course the third one by prosecution. So by these three measures, the Income Tax Act tries to deal with the problem of tax evasion or with the provisions of tax compliance. Now, in fact, if we go a little back in history to understand from where do these stringent provisions of prosecution come into place, if we can see the Wanchu Committee report, it mentions that for the purpose of fighting tax evasion, mere monetary penalties are not enough. In fact, the Law Commission also, in its 47th report in the year 1972, recommends that the provisions with respect to offences and prosecution be incorporated into the Income Tax Act 1961. And also, the Comptroller and Auditor General of India, in its 28th report in the year 2013, which was also presented in front of the Parliament, with respect to the audit of the laws and provisions relating to offences and prosecution, has mentioned a detailed report, and a few instances of the report also mentions that it points out that the CBDT was not taking proper measures for the compliance of section 277. In fact, compounding of offences had not been taken up properly so that the litigation is reduced, and even the CBDT and CBEC were not taking proper measures so that tax compliance and tax evasion is being fought. And what the general takeaway from all this is simple, that mere monetary policies will not help, and the SSE will be fine with paying mere monetary penalties or interest, but however, the idea of going to a prison will definitely bar him from not taking such anti-government steps. Now, understanding what are the provisions under the Income Tax Act which deal with the income tax, which deal with offences and prosecution. Chapter 22 of the Act, which deal with sections 275A to 280D, deal with the provisions of offences and prosecution. However, we'll also have to look at the provisions of Criminal Procedure Code with respect to all the offences under the Income Tax Act. Now, the central government has been empowered for the purpose of constituting special courts with respect to these prosecution proceedings. But however, in case the special courts are not constituted at any time, then the magistrate in whose territorial jurisdiction such an offence has been committed will try such an offence. Now, under the Income Tax Act, when do we say that an offence has been committed at certain place? The place where the false return has been submitted will be called as the place of offence, which means the magistrate court will try such an offence where such false return has been submitted. Now, we also need to understand, is there any procedure which guides the department for the purpose of initiating prosecution proceedings? Now, under the Income Tax Act, or the rules do not mention of any guidelines which have been provided for the purpose of department to be followed, but however, the department follows its own instructions and guidelines. This can also be seen from the Income Tax Department's manual, which provides guidelines for the purpose of initiating prosecution proceedings. A few instances I would like to mention. Firstly, the assessing officer will, or based on the records that is already available with him of the SSE, proposes to the commissioner with respect to initiating prosecution proceedings. Now, the commissioner then issues a show cause notice to the SSE. In case there's a satisfactory reply by the SSC to the commissioner, and he is satisfied that prima facie there can be no case, then he may not give the sanction to the assessing officer for the purpose of filing a complaint in the court. Now, assuming for a moment that he does give a sanction, the commissioner does give a sanction to the assessing officer for the purpose of complaining in the court, then what is the procedure to be followed in front of the court? Now, once the sanction has been provided by the commissioner, the assessing officer then files a complaint in front of the court. The moment a complaint is filed, the court will issue summons. Now, in case the accused, now when I say accused here, the SSC who has done the wrong, assuming that he has done the wrong, then the SSC will have to appear in front of the court at the specified date. In case the SSC does not appear in front of the court, then the court may also issue a warrant. Now, in case the SSC does not apply for a bail, and then he may be arrested and then produced before the court. Now, before even the trial proceeding starts, there have to be framing of charges by the court. Now, in case the court does deem it fit case and deems that there is substance in the complaint that is filed, then the prosecution proceedings will continue as per the Criminal Procedure Code. Now, assuming for a moment that there is conviction by the trial court, what will happen then? What steps have to be taken? The moment there's conviction by the trial court, then the SSC will have to go in appeal before the sessions court, before either the sessions judge or the additional sessions judge. And this appeal needs to be preferred within a period of 30 days. We need to bear this in mind because we do not want to be barred by the limitation period, and we need to file, we in the sense, of course, the SSC will have to file an appeal within a period of 30 days. Now, I would like to deliberate upon a few more aspects with respect to prosecution. Firstly, there has to be a sanction, an appropriate sanction. Now, under section 279, we can see that the competent authority to provide sanction is either the commissioner or the chief commissioner or the commissioner appeals or the director general. Commissioner appeals, chief commissioner or the director general, all of them can provide a sanction. Now, in case there is no valid sanction, then the proceedings shall be void ab initio. Now, one more point is whether there has to be an opportunity of being heard before the initiation of proceedings, the prosecution proceedings. Now, under the Act or the rules, nothing has been mentioned. Nowhere it has been mentioned that an opportunity of being heard has to be given. But however, in the regular trend, what is being seen right now is that the commissioner is issuing a show cause notice before initiating the prosecution proceedings, which means SSC is actually having an opportunity of being heard. Now, a few instances wherein the commissioner cannot initiate the prosecution proceedings is when the circumstances as enumerated under section 273A are existing. Then he cannot initiate prosecution proceedings under section 276C or 277, which means if the circumstances under section 273A should not exist so that the commissioner can proceed with the initiation of the prosecution proceedings. Now, after this, we'll also have one more question, that in case there is initiation of prosecution, can it be before the assessment or after the assessment and during the process of an appeal? Of course, the Supreme Court has mentioned that the proceedings under the Income Tax Act and the proceedings under the Criminal Procedure Code, that is the criminal proceedings, are independent proceedings and they both can run simultaneously, which means during the assessment or even during the appeal under the Income Tax Act, these prosecution proceedings can be initiated. Now, one more question that might arise is what is the effect of the findings of the tribunal? We can divide it into two questions, of course. The first question would be, in case there is a finding of the tribunal that there is no prima facie case in the first place, that is, there is no concealment or there is no false statement, then can the commissioner still proceed with initiating the prosecution proceedings? And the second question would be, are the findings of a tribunal binding upon the trial court? In fact, in case there is a finding of the tribunal that there is no prima facie case against the SSC, then the commissioner cannot initiate penalty proceedings. And the Supreme Court has also mentioned that the findings of the tribunal are binding upon the lower authorities and also the trial court. But however, in case there is a finding of the tribunal only on the technical aspect and not on the merits, then the penalty proceedings may be initiated. And also, in case there is a finding of the tribunal levying penalty, then it does not automatically mean that the prosecution proceedings be initiated. Now, what if the finding of the tribunal uh, in the um, in the quantum proceedings is against the SSC? Then, of course, it is desirable and advisable for the SSC to prefer an appeal in front of the High Court, because in case a substantial question of law is admitted by the High Court, then the prosecution proceedings cannot be initiated. Now, a few more points I would like to mention about is abatement under Section 278. In case there is abatement with respect to either giving the return or giving any false statement or giving any false documents for that reason, then what would be the liability of a CA or an advocate? In fact, Section 278 clearly mentions that an abettor of the crime shall also be liable. Now, the High Court had mentioned that in case it had given a warning that all the legal practitioners should take serious notice of this section, but however, a Madras High Court had also mentioned that in case a chartered accountant is uploading a return based on all the records that are being made available to him, then he cannot be called as an abettor or a conspirer. So we have judgments both in against and in favor, of course. Now, what about the offenses done by companies and who would be held responsible? Of course, in case of a company, the person who's managing and running the business at that point of time when such an offense was committed, he shall be held responsible unless he proves the contrary and he shows that he did it with due diligence and he had no knowledge of how such an offense had taken place, and he proves the same. And in fact, more details about offenses by companies can be found in the article written by Mr. Advocate Rahul Hakani on itatonline.com. What about offenses by HUFs? Offenses by HUFs also, in fact, give out something similar. That is, the Karta will be held responsible for all the acts or all the offenses unless he proves the contrary. That is, unless he proves that he did it with due diligence and he did not have any knowledge about it, or he was not present at that time, or whatever appropriate reasonings he could probably give. Is there any limitation period for the purpose of initiating the prosecution proceedings? The Act or the rules do not mention of any limitation period. Hence, we can understand that there is no limitation period in this case. But however, various courts have mentioned that there has to be reasonable amount of time limit. Beyond that, it may not be able to initiate the prosecution proceedings. Now, one more question that may arise is whether the courts have any power to reduce the punishment. Section 275A to 278A deal with the imprisonment, that is the punishment as provided under the Income Tax Act. But do they have the power to reduce that by, in case the term is 3 years, can they reduce it? Now, under all the sections, it is mentioned shall be punishable. Now, a question will arise whether shall be punishable can be read as may be punishable. The High Court has mentioned that the courts do not have any power to reduce the punishment as provided by the statute. In fact, Supreme Court has also concurred with the same. Now, is there an alternative remedy to this? That is, in case the punishment cannot be reduced, is there an alternative remedy? Definitely yes. In fact, compounding of offenses can be taken, and under Section 279(2), the competent authorities to provide for the compounding of offenses are either the Chief Commissioner or the Director General. Now, such compounding can take place at any point of time, that is, either before the completion of the assessment or during an appeal that has been preferred. But however, once compounding has been resorted to by the SSC, then he cannot take it back. Now, what would be the procedure? Of course, the SSC would have to first file an application in front of the Commissioner. Then they would decide as to what would be the compounding fees. And in case the Commissioner is actually satisfied, he may report the same to the CBDT. Now, one more question that may arise is, in case prosecution proceedings are running under the Income Tax Act, can alternative proceedings be initiated under the Indian Penal Code? Now, definitely the Supreme Court has mentioned that parallel proceedings cannot take place. That is, a person cannot be tried for the same offense twice. Now I would like to provide a brief checklist as to what should be the replies, or what may be the replies in response to the prosecution notices and further replies in the prosecution proceedings. Now, in case there is a search or survey on the SSC and there are some unaccounted assets or undisclosed income that has been found, or incriminating documents have been found, then the SSC should contemplate on whether to approach the settlement commission or maybe go in the regular course of the appeal. In case the additions are made on agreed basis, that is, the SSC agrees to such additions but only for buying peace, then it should be specifically pointed out to the AO that it is only for the purpose of buying peace, and with an understanding that the penalty proceedings will not be initiated. And also, in case the department actually initiates the prosecution proceedings based on certain evidence that it has found, then detailed reply should be filed also in respect of such evidence, so that such evidence is not used against the SSC at a later point of time. In case of a search, survey, or seizure, generally a statement is recorded by the departmental authorities. In that case, the SSC should take care that appropriate replies are being provided to them, and in case any doubt is there, that should also be specifically mentioned that there is a doubt in such a response. And in case the statement was taken under any coercion, then such a statement should be retracted within a reasonable time. In case of a director of a company, they should take care and verify before signing of any return, assuming like TDS return, that such a return is actually verified by any responsible person, such as the manager of the company, just to show that all reasonable care and due diligence has been taken before signing any of the documents. Now, if a part-time director, then they should not be signing the balance sheet or the director's report, because this is for the purpose of showing that they were never involved in the day-to-day management of the business. And the professionals should not use their letterheads or their names while giving any of the documents before the said authority. Now, one more thing is, generally while giving the certificate in the paperwork compilation, it should be taken care, and such certificate should begin only after verification, because if it is found at a later point of time that such verification was wrong, then whoever had given such a certificate, against them the authorities may initiate prosecution proceedings. And in case there are any facts which could have been wrong, then the SSC must file for rectification application and state that so and so facts are correct or wrong. And this can also be done through an affidavit, by filing an affidavit with respect to stating which facts are correct and which are not. In fact, the detailed coverage of everything that I've already spoken can be found in Senior Advocate Dr. K. Shivram's article, which is available on ITAT Online. In fact, even on bail, Advocate Aditya Asgaokar's article is available on ITAT Online. And offenses by companies, the article has been written by Advocate Rahul Haqqani. All of these articles will be available on ITAT Online for detailed references. Thank you so much.